It's been quite an undertaking for Marissa Grace and Deborah Harris and Stephanie Welch and the rest of our Moot board. In the last 3 days, some of you may not have noticed, but there were 112 slots for student bailiffs, 336 slots for judges, and over 1,000 pieces of paper to be processed to get us to this round. So it's been quite an effort, and I want to thank them for their efforts. Also, the problem, which we have heard nothing but great things about this year, was developed by Laura Griffin. Okay. And as you will hear most of the rest of the folks who work hard on this program introduced shortly, I will simply be brief and introduce you to our interim dean for the College of Law, Mr. Greg Bowman.
I will be brief because you were here to see the show and not me. Thank you all again for being here. Thank you to all the students and staff and faculty from the College of Law and the Law School, and for all of you who have come in from other places. You what make this competition a special competition. We're really proud of it. We've worked very hard. It's been a community effort, and the reports on all facets of the competition, especially the teams. It's been top-notch reports. So thank you all for being here. Best of luck to all of you. And I look forward to a very, very exciting, top-notch day for us. Thank you.
Again, I just want to thank everyone for being here. These competitors have worked very hard. I'm sure they're about to put on a great show for everyone here. I'm just going to brief you on the problem for those of you who aren't familiar with it. This is Friends of the Clearwater River versus Seneca Resources Company. This case involves two appeals to the United States Court of Appeals for the 12th Circuit from decisions in two separate proceedings from the U.S. District Court of Vandalia. In its first appeal of the case, Friends of the Clearwater River takes issue with the decision of the District Court in response to a petition for declaratory ruling which found that the natural gas gathering pipeline system, under the circumstances presented in the case, constituted a public utility under common law and as that term is defined in the Vandalia Code and the Franklin Code. In its appeal of the second case, Seneca Resources Company takes issue with the decision of the U.S. Army Corps of Engineers denying an application by Seneca for a dredge and fill permit under Section 404 of the Clean Water Act, which Seneca appealed to the District Court. In granting a motion for summary judgment filed by Friends in the court upheld the court's determination that the wetlands at issue constituted waters of the United States by virtue of their significant nexus to the Clearwater River. Pursuant to the party's request, and consistent with the 12th Circuit's longstanding practice of consolidating cases involving common parties and common issues in the interest of judicial efficiency, these two cases have been consolidated for the purposes of this appeal. In its order granting consolidation, the court noted that the interrelationship of the issues associated with Seneca's proposed construction of gathering lines in Vandalia and Franklin and the regulatory approvals necessary therefore under Public Utility Laws and the Clean Water Act thereby necessitating consideration of the case together. The two issues that will be briefed today are, first, whether the District Court erred in its determination that Seneca is a public utility under the common law, and as that term is defined in the Vandalia and Franklin codes under the circumstances presented to the District Court in the declaratory ruling proceeding. And the second issue is whether the District Court erred in its finding that the court has jurisdiction over the wetlands at issue as waters in the United States under the Clean Water Act by virtue of their significant nexus to the Clearwater River. Now I'd like to introduce Professor Dean Wolfosso, who is going to introduce our fine panel of judges today that will be hearing these contestants.
Marissa, thank you very much, and it is my pleasure to be here today. I'm the faculty advisor for the Moot Court Board, and I will say I work very closely with these students all year round for many different events, and these are among our top students, and this group is, I'm particularly proud of. They are really good. So, Marissa, great job. If anyone else even can, then I've missed so many people, so I'm just going to leave it with Marissa, but there's so many students who've worked on this. And I just want to point out, besides Margaret, of course, is my colleague, Jamie Van Ostrin, who's been the intellectual brains behind all of this. And just thank you. You've been wonderful. So. have 5 judges today, 4 of whom are actual judges, and one of whom is a partner in a very prestigious international firm. We will have Judge John Preston Bailey, who is a judge for the United States District Court for the Northern District of West Virginia. He received his bachelor's from Dartmouth and then came here to WVU to get his JD in 1976. He clerked for Judge Hayden on the United States District Court for the Northern and Southern Districts of West Virginia for 2 years. He was in private practice in Wheeling, which is the northern panhandle, close to Ohio, and part of West Virginia. He has served as an assistant prosecuting attorney in that area called Ohio County in West Virginia, and as a special assistant prosecuting attorney. He was appointed by George Bush to serve as a federal judge in 2007. Joanna Tabbitt, who is really a woman of great leadership in our state, and we are very grateful, especially the women at the law school and the women in the law students are very grateful to Joanna. She is just the governor of our state, Earl Ray Tomlin, just nominated her to be a judge in recognition of all the amazing things she's done in her career. But I think a special thanks to her for being such a wonderful role model to our students. We won't hold against her that she got her undergraduate degree from Marshall, but she did come here and get her law degree. That's an inside joke for West Virginians. Sorry, it didn't go over that. Justice Starcher is a retired, Larry Starcher, a retired justice from our West Virginia Supreme Court. He is a colorful character. He spent his entire life, he comes from the working class, he spent his entire life working with the underprivileged. And you'll never find a bigger advocate for minority rights, for people who are serving those who are in poverty. And then he went on to come from really very modest means to being justice on the United States, on the West Virginia Supreme Court. He now teaches here, and we are very grateful to him and what he's done for our students. Judge Ron Wilson has been a judge, again, at the state level for 34 years. Nothing on the internet about him, and he would tell me nothing about himself. So, which means probably he is an uncontroversial character, so he'll be very fair, right? So we're hoping that. So he will be here today. And finally, Larry Rosenberg is a partner at Jones Day of international renown. He has many energy clients, but he also practices at the trial level, at the Court of Appeals level, and at the Supreme Court level. He also works for free for the law school and is the founding director of our United States Supreme Court Clinic. We were one of only 10 schools in the country, or less, that have a United States Supreme Court Clinic, and we are fortunate enough to have Larry Rosenberg be its director and teaching our students in that particular clinic as part of our very outstanding clinical program under the direction of our clinical director here today, Marjorie McDermott. So with that, I just want to thank you for being here. I know we're going to have a good show, and I would like to turn it over to our Oyez man, Chris Smith, who's also our Baker Cup chair, who is going to allow our judges to finally march in.
Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
I was told to wait for the camera. Is the camera finished?
Yep.
Okay. Be seated. I'm sure you were wondering what in the world is it being waiting for.
It's not just a court, it's a photo op.
That's right. Good afternoon. My name is Larry Starcher, and I know that Ann LaFosso gave you a little bio on us, but I'll say their names to tag a face to what you just heard. On my far left is Larry Rosenberg, who's a professor here, teaches here, and is also a partner in Jones Day in D.C. And my good friend on my immediate left is John, I don't have a mind block. Bailey. I started to say Baker. I said, I don't think so. This is not the Baker Cup. John Bailey from Wheeling, who is a U.S. District Court judge in the Northern District, chief judge right now of that district. On my immediate right is my friend Ron Wilson from up in the First Judicial Circuit, judge of 34 years. And on the far right is a newbie. Joanna Talbot is one of our newest, I think, our very newest circuit judges in the 13th Judicial Circuit in Charleston. And we are happy to be here and be very happy to hear this. As I understand it, this is the 5th annual National Energy and Sustainability Moot Court Competition. We've had schools here from all around. We've had, I think, about 25 teams or something like that. And it's been 2 days, full days, and this is the 3rd day of competition. And I'm sure that the students have worked hard and learned well, and they're ready to show their final works at this time. The way the competition will be run here is we will listen to two, I'll find my notes here. You've heard what the case is about. You've heard a little bit about the case, and I won't recite the whole style. It's a consolidated case. It involves a provider, a gas line company, and it involves some folk, a group of folks that we might call greenies that are interested in environmental concerns, and it involves the utility boards, government boards that regulate utilities and other activities, and so it's a very well-drawn problem, I believe. We will first hear from Seneca Resources Company, LLC. They are the appellant for one of the particular issues we're addressing, and secondly, we'll hear from the Friends of Clearwater River. Is counsel for Seneca Resources Company, LLC prepared to proceed?
Yes, sir.
Okay, you may, you know your times. You may proceed. We have timekeeper, bailiff, Chris Smith, our new Baker Cup winner. You may proceed, and tell us your name as you approach the bench, as you speak.
Good afternoon, Your Honors, and may it please the Court. My name is Ariana Myers, and my co-counsel is Rujeko Musa. We are representing Seneca Resources Company, LLC, in this matter. I'd like to reserve 3 minutes of rebuttal from my time, Your Honors.
You may.
Thank you. I will be arguing that the District Court correctly held Seneca is a public utility under both the common law and as defined in the Vandalia and Franklin statutory codes. My co-counsel will argue the District Court erred in determining the Corps has jurisdiction over the site wetlands. The standard of review, Your Honors, is de novo. Would you like a brief summary of the facts?
Counsel, or Judge?
Yes, I would.
All right. Seneca is a natural gas gathering company with a proposed gathering line. Seneca proposes to service the public at large. The District Court held that Seneca met its burden, proving it is a public utility under the common law and the statutory codes. Additionally,
Did you petition the utility to make that determination?
Your Honor, it was petitioned to the utility. Seneca proactively applied for a certificate to be granted public utility status.
The pipeline at issue, is that an interstate pipeline?
Yes, Your Honor.
Why didn't you petition FERC?
Your Honor, FERC does not apply to this particular aspect because of the fact that we are looking at Section 1B of the NGA, which exempts FERC jurisdiction in this particular matter. And moreover is that the state is in a better position to determine the issue at hand. Seneca is a public utility under the common law. Looking first at the two applicable statutory provisions in Vandalia and Franklin, Vandalia being 625-4-2, stating that anyone or any entity, however associated, incorporated or not, or a municipality which engages in a business that is a public service can be a public utility. The Franklin Code 29.2 states the Public Utility Commission can regulate any business providing a service or a commodity to the public.
Counsel, you indicate that you are proposing, or Seneca is proposing, to provide a service to all of the public, correct?
Correct, Your Honor.
What are you actually doing?
Your Honor, at this point in time, Seneca has 4 previously executed contracts with producers in the area. Now, looking at Public Service Commission of Colorado versus Trigen Nation Energy Corporation, a pipeline which had 2 previously executed contracts that were private in nature was held to be a public utility for 2 reasons. First, that holding oneself out to the public at large is required of a public utility. Second, by servicing someone other than oneself, so someone other than Seneca or Trigen in that particular case, who is unaffiliated, suffices to meet public utility status.
Do you have any contracts with consumers or customers now?
Your Honor, at this point in time, Seneca does not have any contracts with consumers because they are not able to, as this pipeline has not been constructed at this
And
point.
are you proposing that those contracts would be individually negotiated with consumers or would be controlled by a standard tariff filed with the agency?
Your Honor, Seneca is proposing that it is reserving its right to contract on an individual basis, which has been held in Preston County Light versus Rennick, a West Virginia case, that the general rule regarding public utility status is that if you are engaging into privately executed contracts, that is sufficient if there is no unconscionable or oppressive terms. Now, when Seneca proactively applied, as we know on page 4 of the record, to be a public utility, they are volunteering to be regulated by the PUC.
And you would agree that the Mobile Sierra Doctrine would apply to constrain your contracting abilities?
Your Honor, yes. Within the determination of the PUC, the PUC has jurisdiction and would then be able to regulate such contracts to ensure that the public has recourse and the public is protected.
Why do you want to be a public utility?
Your Honor, that's a fantastic question. Seneca wants to be a public utility to ensure that it is able to provide service to Vandalia and Franklin as a whole. Right now, its capacity is limited. They're not able to provide the service with the growth and development of Maximus Shale in the area, which they would like to do. They've demonstrated this intent in numerous ways.
Doesn't have anything to do with eminent domain?
Your Honors, in terms of looking at eminent domain, the court's focus should not be on the result of granting public utility status, which frequently does result in eminent domain when you grant public utility status, but we're looking at here whether or not Seneca is a public utility.
Why shouldn't Seneca be treated like any other middleman in the process of getting natural gas from the ground to the consumer in homes or factories?
Your Honor, looking at case precedents, looking at in particular Brass versus North Dakota, Brass owned and operated grain elevators. They were a middleman, and their products weren't being distributed to the end user. However, the Public Utility Commission granted them public utility service because they said...
That's the North Dakota Public Utility System.
Correct, Your Honor. Due to the fact that Brass was operating an entity that was providing a service deemed to be essential. The public needed the grain in that particular case, and therefore they were granted public utility status. Similar here, natural gas is a service that is utilized very frequently, in fact, on a daily basis.
Doesn't the record tell us that there are people who don't want your pipeline on their land? And if you have eminent domain status, you're suggesting that the public's going to put that pipeline on their land no matter what. Are you going to be compensating them for that?
Your Honor, while the record does not reflect whether these landowners will be compensated for such eminent domain, it is reasonable to infer from case precedents such as the Wilhite case that the public at large, in terms of those specific to landowners in particular, would be able to utilize Seneca's services as just compensation.
You're saying that, wouldn't the public then have a takings claim against you and whatever governmental entity participates in this?
Well, Your Honor, if Seneca were granted public utility status, it would be provided with eminent domain, and therefore that takings argument would not apply.
Wait a second. Eminent domain says you can take land, but you still have to pay just compensation under the Constitution. Who's going to pay?
Correct,
you,
Your Honor.
the state, the utility commission?
Your Honor, the record does not indicate whose pocket the money would be coming out of.
So are you agreeing, will you make a representation here today that your client will pay for it?
Your Honor, what I'm stating before you today is looking traditionally at how this is done. For example, in Cascot Arena, the courts typically how this has been determined is that in that particular case, a private property was utilized to build an arena complex, which the public was able to benefit from. Those landowners, once again, similar to Seneca, did oppose that particular construction of the sports complex. However, the court felt that the needs of the whole in the area trumped and granted the ability to provide eminent domain.
In that case, was the sports complex built in a park, or was it built on people's homes?
Your Honor, a portion of the land was built on private property, which Cascot then acquired eminent domain in order
And
to build.
nobody paid the landowners for their property?
Your Honor, it is reasonable to assume that the landowners, A, benefited from the building of the sports complex as a whole, but also that they were compensated for such.
Right. So that gets back to the question, who's going to compensate these people?
Your Honor, as the record does not reflect at this point in time, Seneca would argue before you today that likely these individual landowners would be compensated in the sense that they would absolutely be able to utilize the service, as Seneca is not discriminating in terms of who they provide service to, but also that this just compensation is well-deserved for use of that land.
Ms. Myers, are there any other companies providing this service in the Vandalia area?
Your Honor, there are other companies currently providing this service in the area. However, none of these service providers, we don't know the exact number of providers, but none of them have applied for public utility status. And it is reasonable to infer that none have applied for a magnitude of this type of pipeline because they would, of course, have to apply for public utility status. Your Honor, in Willite Public Service Commission, there were two entities in that case, one being Wilhite and one being Consolidated. The court was looking at whether, are you a public utility or are you not? Now, Wilhite was not granted public utility status. This was because Willite, with two previously executed contracts, did not have any intent to service the public at large thereafter. However, Consolidated, the intervener, had meetings with owners in the local area, published notice, very similar to Seneca, in local newspapers of its intent, and marketed its services to the public as a whole. So what we're looking at, Your Honors, in terms of whether or not an entity meets a sufficient definition of a public utility is first, whether they're providing a service or a commodity. Seneca is providing a service. It is providing the gathering and transportation of natural gas. Now, contrary, my opposing counsel may come before you today and argue that the end user must benefit from this service. However, the Franklin statutory definition in 29.2 does not state that producers are excluded from the definition of who is the public service, rather that a service or a commodity is supplied and available to the public.
Are there other examples in the public utility regulatory systems that have middleman, if I can call them that, being regulated under the PUCs rather than, or in addition to, the end users? Are there other examples?
Yes, Your Honor. In Public Service Company of Colorado versus Trigens Nations Energy Corp., a middleman, as you're referring to, pipeline gas delivery service was regulated as such because it was contracting with one user who was unaffiliated with them. And here we know from the record on page 6 that Seneca is contracting with 4 unaffiliated producers, thus meeting that requirement in Public Service of Colorado, also meeting the requirement in Wilhite of holding itself out as a public utility for service by any and all who wish to utilize Seneca's services.
Now, that's a distribution pipeline. How about a gathering pipeline? Are you aware of any cases involving gathering pipelines?
Your Honor, in Bucks versus County Board of Commissioners versus Commonwealth, which is a Pennsylvania case, which is geographically and factually similar to the states at hand here today, this pipeline was held, may I briefly conclude?
You may.
Yes.
You may.
Was held to be a public utility because they held out their services and availed to the public at large. For the foregoing reasons, we ask that you affirm the lower court's holding Seneca as a public utility. Thank you, Your Honors.
Thank you. Ms. Musa.
Good afternoon, Your Honors, and may it please the Court. My name is Rujeko Musa. My co-counsel and I represent Seneca Resources Company in this matter. Today, Your Honors, there are two issues before the Court, and I will now be discussing the second issue of whether the U.S. Army Corps of Engineers correctly asserted federal jurisdiction over the wetlands at issue.
What standard did the district court have to apply as it considered that report and finding?
As the lower court considered the Corps' finding, they were supposed to review it with Skidmore deference. And, however, this court reviews the lower court's decision de novo.
Why Skidmore deference and not Chevron deference? Aren't there guidelines that have been issued that were quasi notice and comment in form?
Your Honor, as the court issued the Rapanos guidance, which was supposed to clarify the Supreme Court's ruling in Rapanos versus the United States, this court then owes the agency's determination Skidmore deference, which has persuasive authority over Your Honors, versus the Chevron deference. If we're supposed to be giving deference towards their factual findings.
No. Let's talk about the Chevron deference standard.
Sure.
Chevron deference is applied where you have an administrative agency that either fills a gap or gives interpretation that has the force of law. So if it is notice and comment or quasi-notice and comment, it gets Chevron deference. I don't understand why these guidelines don't get Chevron deference. Maybe you can explain that to me.
Certainly, Your Honors. So as you stated, Chevron deference, that is when an administrative agency has been statutorily empowered to act, such as the Army Corps. And this would require the courts to defer to their statutory interpretations. However, in this case, the Corps is in this case, the agency's view on a given statutory question is supposed to have persuasive authority over the court because we are actually reviewing the Rapanos the court is reviewing the Rapanos guidance, and they're interpreting the guidance.
If it's an interpretive document that's simply a sui generis document, you're right, it gets Skidmore deference. But this is more than that. This is a document that was reviewed by the public, where there was public input, and I don't understand why that's not Chevron deference. Let me ask you this. If we apply Chevron deference, do you lose on this issue?
No, Your Honor. If we apply Chevron deference, we still do not lose on this issue because this court can still overturn the lower court's decision, even if we're applying Chevron deference, if the lower court decision was arbitrary and capricious and if it was not based on substantial evidence. And in this case, what makes the lower court's decision arbitrary and capricious was the fact that the lower court neither conducted an evidentiary hearing nor did they require any additional fact-finding. Rather, they simply took the Corps' assertions as of a nexus. And Seneca's not arguing that perhaps this evidence—
What's the standard, again, that the district court was supposed to review? I'm not talking about the deference standard, but isn't it the substantial evidence standard that the district court would use to evaluate the Corps' factual submissions? Isn't that right?
Correct.
And that's a highly deferential standard, isn't it?
Correct. So the lower court would be reviewing with substantial evidence, and Justice Ginsburg has stated that substantial evidence is simply more than a mere scintilla, and that's not a lot of evidence, and that's not a high threshold to meet. However, this court is reviewing the lower court's decision de novo, and we owe no deference.
No. That's not how it works. We're reviewing a factual determination that was made under the substantial evidence standard. So, yes, we don't defer to the district court's reasoning, but we still apply the substantial evidence standard, right?
Correct. And even if we're still applying substantial evidence as to the factual determinations of the Corps and of the EPA, the opposing party still has not met this burden of providing substantial evidence.
Isn't there evidence in the record that the phosphorus content of the water could be altered by the pipeline production? And you would agree that phosphorus is important to people, right?
Absolutely, Your Honors. And so that's speaking more towards whether there is, in fact, a significant nexus between the site wetlands, Danbury's Ditch, and the Clearwater River. And one of the ways that the Corps could have established a significant nexus is through any sort of a chemical connection. And as you've stated, that could be proven through phosphorus. However, at this time, the Corps has not provided any evidence of actual flow between the site wetlands, Danbury Ditch, and the Clearwater River. And furthermore, if we want to look further into what potentially could be required under this chemical connection, this court should consider the Ninth Circuit's holding in Northern California River Watch versus the city of Healdsburg. And in this case, there was a pond, and it was nearby, and it was adjacent to a nearby navigable river. And there was evidence that the Corps provided that there were increased chloride levels within this pond, which then when it would flow into the river, it would provide increased chloride levels. And the Corps, in that case, it provided expert testimony first of the average concentrations of chloride that were within the pond, and it also provided evidence of what potentially these effects were of these increased chloride levels.
Right, that was something that was already built, right? Here we're talking ex ante, what's going to happen. What is the evidence in the record that the Corps submitted on the change in phosphorus levels? Wasn't it a scientific report from an expert?
On page 9 of the record, and if we look at footnote 5, it does say that they did conduct a study. However, the study was not concluded, and they didn't set a baseline of how much phosphorus was actually in
Who conducted the study?
The Corps conducted the study,
And
Your Honor.
was it like, scientist-type people who did that?
Potentially, Your Honor. I think that's safe to
Who
assume.
actually understand how chemical levels in water might increase or decrease?
That is correct, Your Honor. However, even if it were, in fact, specialists and we should be deferring towards their factual determinations, in creating the significant nexus test, Justice Kennedy himself stated that it is important in order to establish a significant nexus that there be evidence beyond speculative or insubstantial evidence. And so in looking at our record in this case, it may be argued that there is some sort of an attenuated connection because the ditch flows into Asylum Run, which then flows for over a mile through a swamp and into the Clearwater River.
Counselor,
However,
are you arguing that we need to follow the significant nexus as opposed to, say, the plurality opinion in Rapanos or even the dissent? It looked like the court was all over the place in that decision.
Correct, Your Honor. So the court was divided. It issued a 4-4-1 decision, and that left no clear majority. And as a result, circuits have been divided in their application of the case to the Clearwater Act. However, if we look at the Supreme Court's precedent set in Marks versus the United States, when a majority of the Supreme Court only agrees with the outcome of the case and not the underlying rationale, the court's holding is the position taken by the justices who concurred on the narrowest grounds. And the narrowest grounds are understood as the least far-reaching, or in this case, the least restrictive of federal authority to regulate. And because Justice Kennedy's test more frequently will classify waters as navigable, it is the correct test to apply.
What test did the dissent want in Rapanos?
The dissent in Rapanos argued that both tests could actually apply. They argued that the significant nexus test could apply, as well as Justice Scalia's plurality opinion.
And so only Justice Kennedy has said that the significant nexus test has to be fulfilled, right? You have 8 justices saying the plurality test would be okay, and you have 1 justice saying, no, it's only substantial nexus. How exactly do we follow the 1 justice as opposed to the 8 justices?
Well, that isn't exactly correct, is it?
No, Your Honor. It was a 4-4-1 decision. So there were 4 justices who agreed with the significant nexus test, 4 who agreed with Justice Scalia's 2-part test, and then the 1 justice who said, let's follow either. And so in terms of what circuits have actually done in this case, there is a split, and the 11th Circuit has strictly held that only Justice Kennedy's significant nexus test, whereas the 3rd had said both, and all the other circuits have only applied Justice Kennedy's test, but haven't precluded in the future Justice Scalia's test could be used.
But if we apply the standard of common sense, doesn't Justice Kennedy's make the most sense?
Exactly, Your Honor. It provides the least speculative and the more concrete way of determining federal jurisdiction. And not only if this court chooses to follow Justice Kennedy's test, it will it would also coincide with all of the other circuits' previous determination of federal jurisdiction to regulate, as all the circuits have applied Justice Kennedy's test.
That causes me, I struggle to find what you gain by this. We're talking about a ditch, and we're talking about a small section of wetlands. Why is this case important to you?
This case is important to Seneca. We've proactively sought for this dredge and fill permit. We've been proactive. They've been Friends of the Clearwater River, other groups who have been opposed to this pipeline construction, and the record indicates that they've been looking for any opportunity to stop this pipeline from being built. Therefore, Seneca wasn't required to go and seek and file for this dredge and fill permit. We proactively sought this. However, because the evidence that was provided of the Corps over their jurisdiction over the wetlands, it was insubstantial. We have argued to the court that the lower court's decision must be overturned. And so delving further into what could be required under this significant nexus, one thing this court might consider is any sort of hydrological connection between the bodies of water. And in trying to understand what is a hydrological connection, once again, this court should consider Northern California River Watch versus the city of Healdsburg. So in this case, there was an underground aquifer which then drained from the pond into the nearby river. And it was shown that there was a hydrological connection because as the river would overflow, it would cause the two bodies of water to commingle. Also, it was demonstrated that there was a hydrological connection because of an underground aquifer that would serve as a continuous passage and pathway of water.
I disagree there's a hydrological connection here, right? Your argument is that it's only temporary, that it dries up and then the hydrological connection is broken.
Your Honors, we're arguing that at this time the record has not provided evidence of a hydrological connection that is sufficient to support a finding of a significant nexus.
You don't dispute that there is a hydrological connection of some sort. I mean, when the connecting areas are filled with water, there clearly is a connection, right?
Your Honor, that's not correct because there is no actual connection between the site wetlands and the Clearwater River. It must then flow through the ditch into a tributary, through a swamp, and then into the Clearwater River.
Well, excuse me. Finish your sentence. I'm sorry.
So any sort of a connection that could be argued as existing, it may be possible. However, the record has not proven by such simple tests that the EPA has frequently conducted, such as a dye test, which would actually put dye into the water, and then the EPA and the Corps would be able to establish that water from the ditch was in fact flowing to the Clearwater River. And there hasn't been a showing at this time that this is in fact occurring.
Well, is there any way to draw a bright line test as to where this wetland might expand? I mean, we've all crossed the continental divides and the different areas that says all the water this way goes to Chesapeake Bay, this way goes to the Gulf of Mexico. Is there any way to draw a bright line as to where the extent of the waters would be in the wetlands?
Your Honor, so like I mentioned, the dye test is a simple way of establishing water flows and not even measuring exactly how much water is flowing, but if in fact any water that was in the ditch is flowing towards the Clearwater River. Because they are intervening bodies, it could even be flowing in the opposite direction.
Has any case specifically said the dye test is the sine qua non of this, is the key thing that you have to do?
No, Your Honor. There is no test that's binding on this court. However, it was stated in a Hawaii case that they did, in fact, use this dye test, and it is a typical practice that the EPA does. It is not, however, required. It is simply a baseline and an easy test that could have been conducted to at least establish a nexus, much less a significant nexus.
And is there anything in the record as to why there was no dye test performed?
No, Your Honor. There is nothing in the record, and that's what's the issue before this court. There hasn't been sufficient evidence of a nexus. And so looking also towards any sort of an ecological connection that could be argued as existing, this court should consider the holding in Northern California River Watch once again, whereby the court provided evidence that there were birds and there were mammals that would serve along the same migratory path as the pond and the river. And this supported a finding of an integral and an indistinguishable sort of ecosystem connection between the bodies of water. However, in this case, there has been no showing of any bird or mammal that are migrating between the site wetlands and the Clearwater River.
That's because they didn't take sufficient evidence.
That's correct, Your Honor. And
there might be.
And there may be. However, at this time, the record has not shown this, and therefore granting summary judgment was inappropriate. This absence of information requires that this court remand the case for further fact-finding. And in fact, they may be able to establish a nexus in the future. At this time, they simply have not. And furthermore, the Corps might argue that because of the proposed pipeline, if it cuts off the wetland, it could impact phosphorus absorption, which impacts oxygen levels, which then, if there is in fact water, see, there's a lot of ifs. If there is in fact water flowing, then it could it could impact the drinking quality of the Clearwater River as well as the fishing quality within the Clearwater River. However, once again, this is mere speculation. And Justice Kennedy once again stated that when water effects are simply speculative or insubstantial, they fall outside the zone that is statutorily defined as navigable waters. And therefore, in light of these arguments, I'd respectfully ask this court to reverse this decision to the lower court with instructions to remand to the U.S. Army Corps of Engineers for further fact-finding over their jurisdiction. Thank you, Your Honors.
Thank you.
You may proceed.
Thank you, Your Honor. May it please the court. My name is Clay Watkins, and along with Catherine Handy, we represent Friends of the Clearwater River. May we reserve 2 minutes for rebuttal?
You may.
Thank you, Your Honor. This is a consolidated matter with 2 issues before this court. I'll be addressing the first, asking this court to reverse the district court's finding that Seneca's operations constitute a public utility. Ms. Handy will then speak to the second issue, asking this court to affirm the district court's finding that the Army Corps of Engineers, using the power given to them by the Clean Water Act, properly denied Seneca's application for a dredge and fill permit. Your Honors, Seneca is asking this court to adopt a new regulatory framework for the benefit of a private natural gas company and to the detriment of the Johnsons, the Bartons, other members of this community.
Let's talk about that for a minute. How do you have standing in this case?
Yes, Your Honor. Friends of the Clearwater is an environmental organization which represents some 3,000 members, and 2 of those members are the Johnson family and the Barton family. Now, the Johnsons and Bartons have land which Seneca's proposed pipeline would go through. Seneca attempted to enter into contractual negotiations with these families, and the families refused.
Wouldn't they be better situated to bring this case than you, those families?
We represent those families, both of them at the same time in this consolidated matter, Your Honor.
When you say you represent them, they're members of your organization. Do you represent them as counsel?
We intervened in the interaction. We achieve our standing through those 2 members, Your Honor. Accordingly, we ask this court to reverse for 3 reasons. First, under Franklin and Vandelia's code, Seneca's operations are not held to the public. Second, the contractual practices of Seneca show that they offer their business to a privileged and select group of consumers, not the public. And third, contrary to public policy, granting Seneca public utility status would have negative economic and environmental consequences. To our first point, Your Honors, we can see on page 4 and 5 of the record, Vandalia Code 625-3-1 and Franklin Code 29.2 both use the language "to the public" for utility services or other business operations. They can be a public utility only if that is offered to the public. So the question in this case is, what is the public in which Seneca would serve?
Do you agree that natural gas services are important to the public?
Yes, Your Honor, I do agree that natural gas...
And is there any other pipeline currently serving the gathering function that they want to use their pipeline for?
The record's unclear as to if there's any other pipeline serving...
Your colleague said that if anybody else had had a pipeline, there would have been a request for a license just like they're requesting, and because there wasn't such a request, one has to infer that there's no other pipeline. Do you disagree with that reasoning?
I do disagree with that reasoning. The standard practice in Franklin and Vandalia, we can see on page 3 of the record, is that midstream companies traditionally have not sought public utility status. This is the first time that it's happened with Seneca's operations.
Well, maybe they use train transportation or truck transportation, right? And they wouldn't need public utility status to do that. They'd only need it, according to your opposing counsel, if they were running a pipeline. And you're just saying the record's silent. We just don't know if there's another pipeline.
The record is silent to that matter, Your Honor. We do know that the main transmission line, the Mammoth Pipeline, which is on the border of Franklin and Vandalia, is what this would connect to. Now, there are midstream gas companies which have also filed protests to Seneca's operation as a midstream gas operation, and indeed, Franklin and Vandalia's Independent Gas and Oil Association has also filed protest to the notion of Seneca being classified as a public utility.
Counselor, are you saying that we shouldn't classify just Seneca? You want us to limit it to Seneca? Or are you saying all midstream gas companies should not be public utilities?
It would be a case-by-case basis, Your Honor, but Friend's position would be that the normal procedures or the normal way things have played out with midstream companies not traditionally being public utilities would be the norm, because these midstream companies do not offer their services to the public.
What would be so bad about making them subject to the regulatory system of the PUCs, given the fact that you're giving the public then some opportunity to have an agency that they can address, to have some control or at least some input in what those companies do? What would be so bad about that?
Your Honor, the bad thing about that is the eminent domain powers that come along with public utility commissions.
So we are back to the non-issue in this case.
Well, it is the underlying issue in this case, Your Honor. Eminent domain is the driving force that have brought these parties here today. Now, Judge Wilson, you asked why we were brought here today, and Seneca told us that they want to provide this resource to the public in Franklin and Vandalia at large. But we know that if they would have been able to sign these contracts, their pipeline could have been constructed and we likely would not be here. Now, eminent domain is a tremendous power, and Seneca is here today because they could not achieve through private contract what they wanted. And they are now seeking a grant of a public power to take what they were unable to get by contract. Now, the landowners in this case have made clear that they do not want this pipeline on their land. Seneca has made the representation that their business is open to the public and they will serve all comers. But we know that that's a hollow promise, because there are going to be no more customers. The only other people whose land this pipeline will be on have already rejected contracts. And they did not reject those contracts because the monetary incentive was too low. Those landowners rejected the contract because of their concerns for their environmental integrity on their land, and also their nature of protecting their own property and mineral estate rights, which are still intact. To Seneca, this would just be a line on a map, but to the landowners that Friends represents, it's their private property rights. Now, the Texas Supreme Court in Texas Rice versus Denbury, 2012, hypothesized this exact situation. They proposed that if an oil company needed to construct a pipeline and it would traverse a single farmer's land, and that farmer said, I don't want to do business with you, well, it would be very easy for that pipeline company to say, we'll be a public utility and we'll serve the public, when they already have the knowledge that the one member of the public who has access to that pipeline will never utilize it. And that's the exact situation we have here.
Are you saying that the record reflects that there's nobody who is willing to have the pipeline on their land, or it's just that some people don't want to have the pipeline on their land and they can't build a non-continuous pipeline?
No, Your Honor, and I apologize. I didn't mean to suggest that. We know from the record that Seneca already has 4 contracts with landowners, so presumably they have already entered into at least those 4 agreements, which those landowners would be fine with the pipeline being constructed, and the record equally reflects the at least 2 who oppose this pipeline.
So it's basically 4-2 in the record?
At least, Your Honor.
So the 4 people really want this service, right? And it's the 2 people who don't. And the question is there a way to make those, is it more important to make those 4 people happy by providing assumedly just compensation, though your opposing counsel wouldn't concede that there would be just compensation to the 2 people for that benefit for the other 4? And you say, no, it's not appropriate to do that, right?
Your Honor, there are 2 people who have officially filed the protest, the Johnsons and the Bartons, but all 3,000 members of Friends and Spruce County and Vandalia County, in the record on page 5, we can say, have banded together, unified in their opposition to further pipeline and drilling operations in their counties. So it is more than just those 2 people versus the 4. As to the eminent domain issue and the takings that Your Honor mentions, I would disagree with opposing counsel as to the public benefits satisfying the compensation requirement of the takings clause. That compensation, in order to have a proper taking under Kelo v. New London, Supreme Court 2005, we know that for a proper taking, a entity who does the taking has to provide just compensation. That would be fair market value. And if Seneca is the company doing that taking, then Seneca would be the company to pay that just compensation. Further, we know there has to be a public benefit to this. Now, the gas that Seneca's pipeline gathers is not fit for end consumption. We can see the record on page 3 that it still has to be transmitted somewhere and go through a refining process to remove contaminants. And we don't even know where that gas will go. It could go to a single private industrial customer, or it could go to a public end use like the greater population for energy.
Isn't your best argument then that they are a middleman? They're a middleman that it wouldn't be much different. Well, it would be different, but we could go back another step further. What about the manufacturer of the pipe? You want to make them a public utility because it's involved in that? I mean, the best argument, it seems to me, on your side is simply say, this is a middleman. This product is not ready to be consumer used. Therefore, it should not be in a public utility domain.
Chief Judge Starcher, that is certainly a strong argument. We know that the natural gas industry typically has 4 steps: production, midstream services, transportation, distribution. And the transportation and distribution arms of that industry are typically regulated. And it is uncommon for midstream services to be regulated in this matter. As you say, they are simply a middleman. In fact, even if they got eminent domain power, and even if this pipeline were constructed, that in no way would spurn further production because the mineral estates of the landowners who are in opposition to this pipeline are intact. And the construction of a pipeline in no way would give Seneca the ability to compel production. That matter would still be in the sole purview of those landowners, whether or not they wanted drilling or not, and they've already made clear that they do not. This pipeline would be constructed and likely only maintain the same 4 customers which Seneca has already contracted with.
Are you aware of any cases where a gathering middleman company has been given public utility status?
Yes, Your Honor. There's a few situations where it has happened. Recently, in 2011, Laser Northeast Gathering, the Public Utility Commission of Pennsylvania, granted public utility status in that case. But that was granted only after Laser went through a negotiation process with those in opposition. And in part of that negotiation process, the landowners in opposition were able to impart several restrictions on Laser's eminent domain ability, including that it has to be a last resort and it can't be used just to save cost. Shortly after that agreement was reached, Laser, citing business reasons, rescinded their application for public utility status. Further, Your Honor, there are some jurisdictions which statutorily explicitly permit midstream operations to be public utilities.
Permit or require?
Require. Texas, for example, Your Honor, in Natural Resource Code 111 in Texas, the Railroad Commission gets public utility status over midstream operations. But that statute was enacted through a legislative process, not a judicial one, after a rule-making decisions by the Railroad Authority. Kansas and Oklahoma also follow that same model. Now, in Franklin and Vandalia, the legislature has not spoken to this. They passed the 2 statutes at issue today around 1920, and in the near 100 years since that time, no midstream operator has ever sought public utility status.
And you don't think that common law, sufficient common law to allow courts to do it, I presume?
No, Your Honor. If we look to the Drexel Brook Association versus Pennsylvania Public Utility Commission case, Drexel Brook was an apartment complex which wanted to indiscriminately service their tenants with public utilities, which they were buying in bulk and they wanted to redistribute. However, the court found in that case that because they were using contracts to pick their tenants, they had a discriminating class. They were picking and choosing who they were doing business with. So even though the public could be defined as those tenants in the apartment complex, that was still a limited, select, and privileged group. Now, we see on page 4 and 6 of the record that even with public utility status, Seneca has claimed that they reserve their right to pick and choose their customers by the agreement of a tariff and initial contracts negotiations, which would set out the terms of service. Their ability to pick their customers maintains those natural gas producers as a limited, specific, and privileged group. Your Honors, because Seneca is not serving the public, because they've maintained their ability to pick and choose their customers, and because of the risk of eminent domain powers, we would ask this court to reverse the district court's finding. Thank you.
We understand your argument. Thank you. Ms. Andy. may pursue.
May it please the court. My name is Catherine Handy, and as my co-counsel, Mr. Watkins, mentioned, I will be arguing why this court should uphold the lower court's decision that the United States Army Corps exercised proper jurisdiction over the site wetlands. Your Honors, at stake in this case is the prospect of allowing the Clean Water Act to be used in such a way as to encourage environmental harm by way of excluding the Corps' jurisdiction over an area of wetlands that significantly contribute to the integrity of a nearby river.
What do you think the appropriate standard of review here is?
Yes, Judge Rosenberg, and I wanted to touch on that. With respect to this standard of review that we are to afford the Corps' factual determinations, as articulated by the Fourth Circuit and Pre-Con Development Corporation versus the United States Army Corps, we will afford those factual determinations an arbitrary and capricious standard, meaning that so long as the Corps had a reasonable basis for making their factual determinations, those determinations will stand. However, with respect to the guidance memorandum that was released in response to Rapanos versus United States, that will be granted Skidmore deference because there was no notice and comment that was provided. So it is going to be persuasive on this court, much like, for example, a fact sheet from the Department of Labor would be, given that we are talking about an agency that has specialized knowledge and skills with respect to how the Clean Water Act is to be applied to jurisdictional determinations. With this being said, there are 3 reasons why this court should affirm the decision of the district court. First, the site wetlands and their adjacent tributary function in favor of the Clearwater River because the tributary's yearly flows are relatively permanent. Second, because the site wetlands substantially affect the integrity of the Clearwater River via increased drinking capabilities and fishing capabilities, the Corps was correct in its determination that a significant nexus exists. And third, excluding the Corps' jurisdiction over the site wetlands directly contradicts the purpose of the Clean Water Act, which was put in place to mitigate the oftentimes harmful actions of companies like Seneca.
But Ms. Handy, what's your response to counsel's claim that there's no factual basis for this, that there was insufficient facts taken and needs to at least be sent back on a motion for summary judgment to start all over factually?
Well, there certainly is sufficient evidence here to have established the significant nexus, specifically in that, for example, with respect to the tributary's yearly flows, and by tributary I'm referring to the ditch that's running adjacent to the site wetlands. We can see from page 9 of the record that the Corps relied on the water storage capacity of the ditch, as well as its slope and its flow rates. So specifically,
they didn't do a dye test, though, did they?
That's correct, Your Honor, that
Why
in this particular case, there was no need to do a dye test because, and opposing counsel referenced specifically the Northern California River Watch versus City of Healdsburg case that came out of the Ninth Circuit in which a dye test was conducted. However, what's important to note is that the Ninth Circuit never reasoned that a dye test was necessary to establish a significant nexus. Rather, we can see from Pre-Con Development Corporation that the Fourth Circuit articulated that rather than quantitative measurements like dye tests, rather we can rely on qualitative measurements in full to determine if, in fact, a significant nexus exists. So, again, while there wasn't a dye test conducted in this particular case, there was no need.
But do you dispute that a dye test would be definitive? Right? I mean, if the dye travels all the way, then there's clearly a connection, right?
A dye test could be a definitive measure, but what also is a definitive measure that the court did utilize is, as we can see on footnote 5, page 9 of the record, that in 2002, the Corps actually did conduct a study on the Clearwater River and determined that it was impaired due to high levels of phosphorus. Now, that's so important to our discussion here today because the Corps was likewise able to determine that the wetlands are able to absorb phosphorus and thus preclude it from freely flowing into the Clearwater River. And that goes directly to the purpose of the Clean Water Act and why Congress enacted it in 1970. The Clean Water Act was put in place not just to restore our nation's waters, but to maintain our nation's waters. And as the District Court for the Eastern District of Virginia noted in Pre-Con Development Corporation, that A body water does not need to be impaired in order to establish that an adjoining wetlands is in fact significantly contributing to it. So in this case, while we can see that the Clearwater River, or rather there's sufficient evidence to show that the Clearwater River is to some extent impaired due to the phosphorus concentrations, what's more important to note is that the Corps was able to determine that the wetlands running adjacent to it, the site wetlands, by virtue of absorbing that phosphorus, are helping to maintain that nation's waters. And that goes directly to why the Corps was charged with enacting the Clean Water Act and also making these jurisdictional.
Do you think it matters whether the substantial nexus or the plurality test from Rapanos governs here?
In this case, Your Honor, regardless of the test, we could apply and sufficiently pass both. However, as we can see from page 2 of the record, the issue on appeal that Seneca has raised is whether the Corps properly applied or found a significant nexus. So by virtue of that, we will be applying the significant nexus test because that is the test that is raised on appeal. However, as
we can apply whatever test is correct under the law, isn't that right?
Well, yes, Your Honor. Certainly this court is free to apply any test it so chooses.
And so if we think the substantial nexus test isn't the controlling test, the question is, does it affect your position at all? And if so, how?
It does not affect our discussion here today, nor our position, because even with the plurality test, which is essentially a 2-element test, we can still satisfy both of those elements, primarily because there is sufficient evidence to establish that the tributary has a relatively permanent flow, which is the key factor in the plurality
What
opinion
exactly
test.
is the evidence in the record? Could you detail that for us for just a minute?
Certainly, Your Honor. As we can see from page 9 of the record, the Corps conducted a number of studies that showed that while flows vary from year to year in the tributary, some years the flow is from January to May. However, in 2002, there was a dry period, or drought, if you will, lasting approximately 3 months. Now, speaking first to the 5-month relatively permanent flow we see in some years, the January to May, that's important because, as the Corps and EPA articulated in their Rapanos guidance memorandum, when we're making these types of decisions as to whether relatively permanent status needs to be conferred to a ditch in question, we're going to be looking to whether the flow is year-round, or it also allows for seasonal flows lasting at a minimum for 3 continuous months. So by virtue of that data point that we know 5 months it's continuously flowing, we're actually 2 months over the required minimum articulated by the Corps and EPA. Now, with respect to the drought we see in 2012, that is inconsequential because, as Justice Scalia noted with respect to this relatively permanent test in his plurality opinion, Justice Scalia articulated that we're not going to punish tributaries, if you will, for seasonal changes or temporary periods of drought. So considering that the only indication we have is that at one time in 2012 there was a 3-month drought, that will not preclude this ditch from...
Let's assume we agree with you that there's enough evidence here that there is a connection in terms of water flow.
Yes, Your Honor.
What about on the phosphorus analysis? What's the evidence in the record that shows that there's a meaningful effect on the phosphorus level in the river from this particular property?
Certainly, Your Honor. So when we look to footnote 5 on page 9, we can see that there has been a study that's conducted that shows that the Clearwater River was impaired due to high levels of phosphorus.
Where's the connection to this particular property?
The connection is in the fact that the wetlands, by virtue of their geographic closeness to the river, are actually able to absorb extra phosphorus from freely flowing into the river and impairing it in the future.
But there's nothing in the record, is there, that says how significant, how much that absorption would be based on whatever hydrological connection there is. In other words, it's not quantified, it's not measured, it's not been subjected to testing, and doesn't that fit in with your opposing counsel's argument that we should remand for further factual findings?
It certainly would, Your Honor, if the Army Corps was required to provide quantifiable measurements. But as the Sixth Circuit has articulated in United States versus Cundiff, in fact, the Corps and EPA are not required to provide quantifiable measurements in order to show a significant nexus with respect to whether a river is impaired by exactly how much of a certain agent. Now, phosphorus is going to, there will be traces of phosphorus in every water body. However, as the EPA noted in a water monitoring assessment in March of 2012, even a fractionally small increase in phosphorus can drastically change the aquatic life and ecosystems within a river, and to that river's detriment. And what we certainly want to articulate here is that we don't want to wait until it's too late, if you will. Rather, we don't want to fill wetlands and then, after the fact, realize that...
Is the Corps' argument that this would affect drinking water suitability, or it would affect aquatic life, or both, and it doesn't matter?
It would be both, Your Honor. It doesn't matter in the sense that the Corps has to show that, yes, it will affect both fishing capabilities and aquatic life, things of that nature. But we can see from page 9 of the record that the Corps was able to make a factual determination based on the wetland's ability to hold that phosphorus, that in doing so, it would be significantly affecting the increased likelihood of fresh drinking capabilities as well as increased fishing capabilities. And
would that conclusion differ if they had applied the plurality standard in Rapanas as opposed to the significant nexus standard? And is that going to make a difference?
It would, Your Honor, to the extent that the plurality opinion asks us to focus more on the tributaries' yearly flows, whereas the significant nexus test asks us to assess whether the wetlands are significantly contributing to the biological, chemical, and physical integrity of a nearby river. So this analysis as to, for example, the phosphorus and how it's impacting the biological integrity of the Clearwater River is not necessary in the plurality's opinion, because we'll be focusing on the ditch's flows. However, with respect to the significant nexus, it certainly is the crux, if you will, as to whether, in fact, there is jurisdiction with respect to the wetlands. Now, in moving to my second point, which is that the site wetlands do, in fact, impact the Clearwater River, and its tributary also affects the Clearwater River through its physical, chemical, and biological integrity as required by the significant nexus test. Now, in going to the physical impact that both the tributary and the wetlands have on the Clearwater River, we can see that the tributary in question has a very low slope, small slope. Rather, it has 0.03%
What's
slope.
the body of water, counsel, that you are referring to that constitutes the tributaries?
The tributary is the ditch, Your Honor, that runs adjacent to the site wetlands.
So the ditch is essentially a navigable body of water?
It doesn't have to be a navigable water, Your Honor. Rather, a tributary can still be a non-navigable water. And with respect to whether it being man-made would preclude it from being a tributary, we can see that both the Corps and EPA have articulated in their guidance memorandum that, in fact, just a tributary a ditch cannot receive tributary status just because it's man-made. Tributaries can be both naturally made and man-made and still qualify within a significant nexus finding. And so it's for these reasons we would ask this court to affirm the decision of the district court for the District of Vandalia. Thank you.
Before you conclude,
Yes,
let me ask you this question. Given that there's uncertainty here, right, there's uncertainty as to whether Seneca could negotiate more contracts with some of the individuals, perhaps offer them more money, perhaps offer them the kinds of assurances that your counsel mentioned in other cases, and because at least of the concern that there hasn't been a more direct connection shown between the condition of the wetlands and the phosphorus level in the river, wouldn't it be more prudent to remand for further factual analysis, but a limited remand where we set out specific questions that the district court should have Seneca or the Corps answer on remand?
Sir, Your Honor, remand would, and I see that my time has expired. May I answer your question, conclude? Thank you, Your Honor. Remand is not appropriate in this case because while opposing counsel has argued that perhaps there need to be more quantifiable measurements with respect to the exact phosphorus levels in the Clearwater River, we can look to a similar case to see that, in fact, remand was not appropriate when it was issued. In Precon Development Corporation versus the United States Army Corps, the Fourth Circuit remanded to the Eastern District of Virginia and asked that court to essentially ask the Army Corps to provide quantifiable measurements as to nitrogen levels in that river. And on remand, the Eastern District of Virginia essentially said that these quantifiable measurements were not necessary and that the Corps did not need to provide them in order to still satisfy that significant nexus.
Thank you.
What did the Fourth Circuit say about that? When the Eastern District said they didn't have to do more quantifiable, what did the Fourth Circuit say?
It has not been reappealed, Your Honor. In fact, the Precon case has stayed in the Eastern District of Virginia, and the Eastern District of Virginia affirmed that the Corps' determination that a significant nexus exists.
Tuesday, the Fourth Circuit affirmed Precon.
Yes, Your Honor. Thank you.
Thank you. Ms. Byers. You have 3 minutes.
Thank you, Your Honor. One issue on rebuttal today, and that is whether Seneca has met its burden of proving it is a public utility under both the Vandalia and Franklin codes and under the common law. The Vandalia and Franklin codes clearly allow a midstream provider to be regulated. Furthermore, the codes allow for service to be provided to the public to mean those other than end users, such as unaffiliated users. Seneca has met both of these requirements. Seneca wishes to be regulated and thus has applied for such regulation. And furthermore, Seneca is currently contracting with 4 unaffiliated users. The focus of this court should be whether Seneca is or is not a public utility, rather than the effect of granting public utility status. For these reasons, we ask that you affirm the lower court's holding Seneca as a public utility. Thank you, Your Honors.
2 brief points on rebuttal, Your Honor. First, the opposing party states that it can meet the burden as set by Justice Scalia, but it is a 2-part test. So while the water's flows may meet that burden of permanency, it still must meet the burden of adjacency. And in this case, if we look at the record, there is a berm which separates the ditch from the wetlands. And this berm is specifically precluded by the Rapano's guidance, which states that the existence of a berm, an upland, a dike, or a similar feature does not establish abutment and therefore does not establish adjacency.
Does it say it can never establish it, or it might sever the link?
It says if there is an existence of such a thing, it severs the continuous surface connection. And also on rebuttal, I'd like to address the footnote that my opposing party has referenced on page 9 of the record. And in that footnote, it states that the Corps has conducted a study regarding phosphorus absorption. And at this time, the Clearwater River has a high phosphorus level, regardless of whether or not a pipeline has been built and thereby has impacted the wetland's ability to absorb phosphorus. So even without establishing this flow, we haven't established that building a pipeline would actually impact the ability of the wetland to absorb phosphorus, which would thereby impact the Clearwater River. The study conducted thus far was simply about what is the baseline amount of phosphorus that's in the Clearwater River right now, not about what impact having a pipeline would have over the current amount that exists. Thank you, Your Honor.
Thank you. Ms. Ann.
Your Honors, 2 points on rebuttal. First, with respect to the adjacency argument that my opposing counsel made, while it is in fact true that there is a berm, as we can see from page 9 of the record, what I would like to also note is that that berm is daily eroding. This ditch has not been maintained since the 1990s, and in fact, the berm is now displaying holes within it. So, and And the berm additionally, as we can see from page 9 of the record, is an average of 6 inches in height. So we're certainly not talking about a very large berm that's capable of serving as a strong boundary wall, if you will. We're talking about a low...
Did the course analysis account for the berm?
It did, Your Honor, yes.
How do we know that?
We know that the Corps took it into account by virtue of it being a factual determination that the Corps made, as we can see in the record. Additionally, with respect to the phosphorus levels, opposing counsel mentioned that, in fact, the Clearwater River is impaired due to phosphorus. And that is exactly what the Corps should have looked to and reasonably relied on when determining that, in fact, the wetland's ability to withhold more phosphorus from flowing into the river certainly serves an important function in determining whether a significant nexus exists. So it's for these reasons we would ask this court to affirm the decision of the district court with respect to the Clean Water Act issue. Thank you.
Mr. Watkins,
I believe we're out of time, Your Honor.
do you want a couple of minutes rebuttal?
With Your Honor's permission.
You may.
Thank you, Your Honor. In respect to the issue of contracts, the Indiana Superior Court of Appeals found in BP Products North America versus Indiana Department of Consumer Counselor that if a statute reads to the public, then contracts are preclusive. In the event that the statute, as it did in Indiana, reads to a consumer, then statutes are then contracts can be appropriate for public utilities. In Franklin and Vandalia, the statutes both read to the public, and Seneca's contractual practice then precludes them from being a public utility. Thank you, Your Honors.
The court will recess for a few minutes.
The pictures?
No pictures. Well, as you folks in the audience would have noted, this was a exceptionally well-prepared two teams, that they knew what they were talking about and that they spoke very well and have every reason to be very proud of themselves, as I know their schools will be proud of them. But the runner-up in this, and I was asked to give these percentages, I probably wouldn't have done it. It had been my choice, but it's okay. I try to do what I'm told to do sometimes, folks. University of North Dakota with Ariana Myers and Rujiko Musa. Runners-up with 90% plus, 90.48%. And the winners, Texas Tech University, representing Friends of Clearwater River, Catherine Handy and Clay Watkins with 94.29%. Very close. We're going to come down and shake their hands. Joanne, you want to? Sure. This is the way the West Virginia Supreme Court generally does it. On the close of argument there.
You're not going to be able to get